Comparisons between the common law and the civil law abound, and mostly these comparisons are from the perspective of the person undertaking the comparison, that is, from the perspective of the legal system to which this person belongs. Even the key features through which the comparison is to be undertaken depends on this perspective. Our comparison is also based on our needs. Accordingly, if we say that the common law has a certain feature, it might apply to the legal system of the United States of America and not to that prevailing in the United Kingdom, or vice versa. Thus, if we say that common law systems usually have unwritten constitutions, then this is not true, as it is only the United Kingdom that does not have a codified constitution. If we say that in common law systems, statutes can be subjected to judicial review, then this is not true of the United Kingdom. The same applies to civil law countries, as some of them may have slightly different legal systems. This is where the distinction between a legal tradition and a legal system becomes significant. Our comparison will, therefore, focus on the most prominent and general features. Where we need a feature that is not uniform, we will indicate this. Countries in the three traditions. Muslim countries follow one of the two legal traditions listed below, but mostly as mixed systems. The Kingdom of Saudi Arabia and a few other Persian Gulf countries may have their own unique systems, but they have definitely borrowed from the two traditions. Before colonization, Muslim countries used to follow one of the four Sunni schools, with a few following the Shia schools. The Hanafi school was the predominant system. It was followed by states in Europe, including Turkey up to the Central Asian states and down to what is now Bangladesh. North Africa followed the Maliki school, along with one or two Persian Gulf states. Spain also followed this school till such time that it was Muslim. Egypt, Arabia, and the Far East followed the Shafi school. By the common law system, we mean the legal system prevalent in England and in many countries with a history as British territories or colonies. By civil law, we mean the legal system in the majority of countries, especially in continental Europe, in the former colonies of those countries. There are three distinct subgroups within the civil law countries: French civil law, German civil law, and Scandinavian civil law. Turning to the sources of law, we may say that the source of religious law is the deity, legislating through the prophets. Secular law, however, is made by human beings. The rules of Islamic law have been derived from more than 600 verses of the Quran and about 1,800 or more traditions from the Prophet, peace be upon him, as recorded by the sound compilations. The rules are, however, discoverable from the manuals of the different schools of law. It is important to note that the law of the Hanafi school was finalized before the 6 sound compilations of traditions appeared. There was no codification in the Islamic legal system, and the system worked on the basis of uncodified law, much before the common law appeared on the scene. In common law, a legal rule is judge-made. Common law originally developed from rulings of judges that were based on tradition, custom, and precedent. Today, statutory law is the major source of legal rules. The primary source of law was cases originally, but today, statutory law, legislation, is equally important, if not more. In civil law, a legal rule is laid down in the form of a legislative enactment based on the doctrine of legislators and legal scholars rather than on the practice of the courts. Legislation comprises express legal rules in a general and comprehensive manner. The primary source of law, then, is legislation. As far as uncodified sources are given greater importance, there is a striking similarity between Islamic law and the common law. Civil law, on the other hand, relied more on codified law. While Islamic law had the texts of the Quran and the Sunnah for the derivation of rules, common law was in need of creating its own texts in the form of codes that became the source of rules. The next feature for comparison we may call the oracles of law. By oracles of the law, we mean those who will tell us what the law is. In the common law, it is the practitioners and judges who tell us what the law is. Jurists of the type prominent in civil law systems do not exist in the common law tradition. One writer summed up the basic distinction between the common law system and the civil law system in terms of the role of jurists as follows. The most striking difference between the civil and the common law lies in the greater relative importance which, in the former system, is attributed to the opinions of jurists as compared with prior decisions of the courts. As the common law was based on Norman as well as Saxon law, the only legal content available was the decisions of the judges in the two streams. The tradition of scholars or jurists did not develop. The decisions of the judges, therefore, assumed importance, leading to a system of precedents. The elevated importance of judicial precedent gave more authority to the judges and to their opinions. Consequently, there was no need for legal scholars to devise and develop a comprehensive system of law, nor was there a need for the methods of legal science to arrive at a decision in a case. Precedent thus obviated the creation of a body of jurists of the kind found in civil law countries. In civil law, greater respect is granted to academic lawyers. It is the legal scholar who does the basic thinking for the legal system. Therefore, they are given an honored place in the civil law tradition. Judges and legislatures, as a general matter, look to legal scholars for definitive views on the law. Though legal scholarship is not a formal source of law, the doctrine as developed by scholars is highly valued in the civil law tradition. The judge's role is a simple and narrow one, limited by strict notions of legislative supremacy. Civil law judges, in theory, are the operators of the system designed by legal scientists and built by legislators. Since there is only one correct solution to a legal problem, according to legal science and the developed doctrine, judicial discretion or interpretation becomes largely unnecessary. In Islamic law, the respect and honor granted to the jurist is even greater. The law is elaborated and stated by the jurist. There is one difference, however, when it comes to the role of the judge. The basic role of the judge is the same as in civil law, unless the judge himself is a jurist, and by that we mean a mujtahid. In such a case, the judge will theoretically determine the law himself, but practically he has to stay within the confines of his school. The formation of schools in Islamic law has also given rise to a major difference between the civil law and Islamic law. There can be as many views about a law as there are jurists. Accordingly, the school has preferred a single view within the school. Thus, it is not the view of a jurist that is important for the judge, but the view of the school. He is bound by the school opinion. In general, however, the question as to who the oracle is has been answered in a more or less similar way by Islamic law and the civil law. The common law went its own way and gave importance to the view of the judge, which led to the formation of a system of precedents. And the third feature is that of codification. The methodology of common law revolves around a case-based system of law, which functions through reasoning by analogy and precedent. The doctrine of precedent, or stare decisis, who stand by the decided matter, that is, the previous decision of the highest court in the jurisdiction, is binding on all other courts in the jurisdiction. A case's authority for what it actually decides. The common law may be unwritten or written in statutes. A common law statute does not propose to completely supersede the pre-existing traditional law governing topics covered by it, nor does it propose to lay down general principles of its own. General principles underlying the statute are to be found within the realm of the traditional unwritten law. Statutes may leave a number of things unsaid because they are already understood from the point of view of pre-existing case law. The main function of a statute in the common law is that of clarifying doubtful points and implementing pre-existing rules and principles. Some statutes are purely statutory and may create a new cause of action beyond the common law. The courts have recourse to doctrines of common law and statutory interpretation. As compared to common law, the methodology of the civil law is based upon codification, legislation developed out of the Roman law of Justinian's Corpus Juris Civilis. We have already discussed the recreation of Justinian's Codex in the 13th century. This movement culminated in the 17th, 18th, and 19th century enactment into separate national codes. The most influential codes are the Napoleonic Code and the German Code. The code provisions have been implemented by an increasing number of statutory provisions. According to the civil law principles, the solution of each case is to be found in the provision of the written law. Precedents, however authoritative, are not binding. The deciding court, however, must demonstrate that its decision is based on provisions of the written law and not merely on precedent. As stated above, the written law is the governing law and controls all decisions. The decisions of the civil court, called jurisprudence, are an illustration of general principles. Precedents may be highly persuasive, but they are never conclusive. In Islamic law, the need for codification did not arise, as it did in the civil law system, due to two reasons. The first was the existence of the texts of the Quran and the Sunnah, which were the main source to which the jurist would turn, and even the judge if he was a qualified jurist. The second was the existence of the authoritative texts of the schools, known as the mutun, plural of matan or text, which served as substitutes for official codes and which were highly respected due to the honorable status given to the jurists. The role of the judge, or ghazi, was more or less similar to the judge in the civil law. He had to ensure that he was not moving outside the limits set by the school. There was no system of precedence for the judge, but the qawaid fiqhiyya were created through a process of induction from the cases arising from the texts, a function that precedents basically perform. We then come to a feature called adversarial or inquisitorial. The procedure practiced in common law courts is the accusatorial or adversarial system. That is, there is a regulated confrontation between the parties. Extensive laws of evidence and trial methods have been developed. The judge is passive. The leading role comes to the parties and their lawyers. This too may have something to do with the history of court practice in England. Cases were usually settled by barons, who had little knowledge of the law and procedure. Lawyers from both sides guided the judge, whose role was passive. As compared to this, procedure practiced in the civil law courts is inquisitorial. The judge is given a strong role. The judge can adopt the role as examiner, counselor, and advisor, as an insistent promoter of settlements. He is entitled and bound to question, to inform, encourage, and advise parties, lawyers, and witnesses and counteract any mistake. Our purpose here is not to go into detail. An excellent summary of the legal process is provided by Apple and Daling for those interested in further details. Maqdisi has tried to show that the procedure followed by the Qadi was probably a model for the common law judges and procedure. We find it difficult to agree with this. In our view, the procedure before the Qadi was more or less inquisitorial, and that followed by the Siyasa or the Mazalim courts was completely inquisitorial. The main aim of these courts was the discovery of truth, as far as that was possible. The final feature may be an examination of international law from the perspective of the three systems. A quick look at the sources of international law shows that these sources have been fashioned after the general features of civil law. This is natural as most of the initial contributions came from Europe after the Treaty of Westphalia in 1648. Consequently, the features of Islamic law will not appear alien to international law. The role of the publicist or the jurist was once very important, but today the decisions of the internal courts of justice are gaining greater significance. Codification in the form of multilateral treaties has increased considerably with the passage of time.